Friends, welcome to my channel. Today I'm going to talk on Code on Wages 2019. My focus for this session is wage definition and its pros and cons. As you know, the Code on Wages is already notified as an act. Now it is waiting for the implementation date. Already the central government has notified the draft rules for comments and suggestions. Before we begin, this is my short profile. My name is Govind Raj. I work for a company called Kern Libers as General Manager HR and ER. I have also authored few books and made few quiz and also wrote articles on labor law and labor relations. You can visit my website www.labor-relation.com for details on my literary works, which includes books, articles, and quiz on labor law and labor relations. The section 2Y of the code defines salary or wages. As you may know, the Code on Wages has subsumed four legislations, namely the Minimum Wages Act 1948, the Payment of Wages Act 1936, the Payment of Bonus Act, and the Equal Remuneration Act. The definition provided in section 2Y of the code is applicable for all these four aspects. A single definition is provided under the code. This definition is very important because this is applicable for the entire code and its provisions. Now let's read the definition. Wage means all remuneration, whether by way of salary, allowances, or otherwise, expressed in terms of money or capable of being so expressed, which would, if the terms of employment express or implied were fulfilled, be payable to a person employed in respect of his employment or of work done in such employment. If the code would have left at this part, or it is only defined the first part, then there would have been no ambiguities or complexities. The complexity arises in the wage definition because it has two parts, the inclusion part and the exclusion part. The inclusion part includes basic pay, dearness allowance, and retaining allowance. However, retaining allowance is not defined in the code. The retaining allowance is relevant for the industries, specifically seasonal industries, where they work for certain months of the year. When there is no work, the employer pays certain allowances to keep their services. This is called as retaining allowance. The inclusion part, as I said earlier, it only covers basic pay, dearness allowance, and retaining allowance. There is another important parameter which talks about the remuneration paid in kind. If any amount or any remuneration paid in kind which exceeds 15% of the total wages is not part of the wages. However, if it does not exceed 15% of the wages, then it is deemed to be part of the wages. This is also relevant for certain agricultural based industries and also for hotel industry. If you notice the notification, the minimum wages notification of hotel industry of Karnataka government, the remuneration paid in kind to a limit also forms part of the wages. Now let's proceed. We have seen the inclusion part. Now let's look at the exclusion part. The code says there are 11 kinds of components which are excluded from the definition of wages, and they are excluded components. The bonus under any law is also excluded. Even the bonus paid under this code is also not wages. That means it is an excluded component. If any employer pays or provides any amenity or service like house accommodation, the supply of light, water, medical attendance, etc., these kind of services and the value of it is also not covered under the inclusion part. Any amount paid towards PF or pension fund as contribution is also excluded component. And please note, the conveyance allowance or value of any traveling concession is also an excluded component. The word conveyance allowance is very specifically brought. If we look at all the four legislation, the word conveyance allowance is not to be found. However, the legislation has understood the current standards and the allowances which are being paid in the industry. Therefore, it talks about conveyance allowance. Next component is any sum paid to defray special expenses which may entail on the employee due to his nature of employment is also an excluded component. This is relevant where any employer pays any expenditure towards any activities related to his employment. For example, certain allowances like hardship allowance, eat allowances, washing allowances, these are all can be brought under this provision. Such expenses are not covered under the wage definition. Now let's look at another component, which is house rent allowance. The house rent allowance is an excluded component. This I will address it in the later part of this presentation. Remuneration payable under any award or settlement, overtime allowance, any commission payable, the gratuity payable on the termination of employment, any retrenchment compensation, retirement benefit, or any ex gratia paid on termination of employment, these are all in excluded part of the wage definition. This is where the employers or the HR professionals gets into lot of complexity and doubts. Let's proceed. As I said earlier, the HRA now is excluded component, whereas if we go to the Minimum Wages Act 1948, section 2H of the act covers house rent allowance is an included part, and it is also forms part of the wages. Even though the government notifies only basic and DA as wages, if the employer is paying equal to minimum wages or more than the minimum wages, which also includes house rent allowance, then the compliance would have been done, and it was not necessary to show basic and DA as defined or as notified in the minimum wages notification. The Honorable Supreme Court in Air Freight India versus State of Karnataka also clarified this point. It said employer need not to pay entire minimum wages as basic plus DA. The employer can split minimum wages provided wages are structured as per section 2H of the Minimum Wages Act. The authority cannot insist for paying minimum wages as basic plus DA. Now this situation will change because the inclusion part covers only basic plus DA and retaining allowance as the minimum wages. The government, if fixes basic and DA as wages, then it is an obligation on the employer to make sure that the basic and DA is not below the notified levels. There is another important part. While considering wages for the purpose of equal wages to all genders for equal remuneration purposes, the conveyance allowance, value of any traveling concession, house rent allowance, remuneration payable under any award or settlement, and any overtime allowance should also be counted as wages for this purpose. Let's proceed further. There is an important provision under section 2y of the code as first proviso, which reads, if the excluded remuneration exceeds other than a gratuity, retrenchment compensation, retirement benefit or ex gratia, one of or such other percent as may be notified of all the remuneration covered in the inclusion part, then such excess should be treated as remuneration wages of the inclusion part. If we read the text of all the subsumed four legislations, this condition or this provision was not part of all the four legislations. Let me explain in detail about this. As I said earlier, there are two parts, inclusion part and the exclusion part. If the exclusion part of the wages exceeds 50% of the wages, then such excess should be added back to the wages in the inclusion part. So such wages will be treated for the purpose of the code, including payment of bonus. I am also aware that the same definition will also be brought in all other codes. That means for all the other benefits including gratuity, this definition may hold good. The basic idea, if I understand from the legislator's point of view, normally the employers used to keep the basic and DA as less as possible and the other allowances as high as possible to keep the costs at the minimum level, including payment of bonus, gratuity and provident fund contributions. Probably it looks like the legislation would have understood this and hence they have provided this provision. This provision creates a lot of confusion and understanding issues. Let's proceed. Because of this provision, the salary structure of employees may need a review if it does not comply with this provision. Let's take an example. I have given this structure considering the current practices in the industry. This has got most of the allowances, which is basic, DA, HRA, conveyance allowance, washing allowance, education allowance, medical allowance, special allowance, which amounts to 20,000 rupees. And employer contribution is limited to contribution on 15,000, that is rupees 18,000, and I have also provided leave travel allowance of rupees 1,000 rupees. And total remuneration works out to 22,800. If you notice, this wages attracts also ESI contributions. I have specifically not calculated for this purpose, which I will explain later. Now let's calculate what amounts to wages or salary in the inclusion part, what amounts to remuneration in the excluded part, what is the excess of 50% of inclusion part, and by doing this, what is the revised inclusion part. If we arrive at these four parameters, then probably our understanding will be clear. I have tried to analyze this structure based on the provisions of the code provided in section 2y of the code. If you look at the inclusion part of the wages has arrived at rupees 13,300. The inclusion part of the wages is the basic, which is very well is included, the DA is very well is included, then the education allowance is also included because there are no specific exclusions are available. Same goes with medical allowance and the special allowance. This special allowance is not tagged to any special kind of allowances as to defray special allowance. Hence, it is also included, and rest are all are excluded components. If we look at the HRA, there is a clear exclusion. Conveyance allowance, there is a clear exclusion. Washing allowance under section 2YE to defray special expenses is excluded. Then PF, employer contribution under section 2YC is excluded. Then the leave travel allowance under section 2YD is excluded. The ESI employer contribution is not calculated because there is no direct reference in the code about this exception. However, considering it as a legal contribution, it is not taken for calculation of wages. Now we have arrived at 13,300 as inclusion part and 9,500 as exclusion part. Now how to arrive at the revised inclusion part of 16,150? If we make the 50%, if we take the 50% of the inclusion part, that is out of 13,300, 50% works out to 6,650. This amount has to be subtracted from 9,500. So if we subtract, we get 2,850, which is excess of the inclusion part, 50% of the inclusion part. This has to be added back to 13,300. Then the revised inclusion part works out to 16,150. Please note, the percentage of wages in the inclusion part to total remuneration was earlier 58.33%. Now it is increased to 70.83%. That is why the legislation has provided this proviso. Now this is where the complexity arises. If you look at the bonus part, the bonus is excluded component. If it is an excluded component, it has to be counted as an exclusion part. It is paid on an annual basis. After counting as an excluded part, if it exceeds 50% of the wages, then the excess of 50% has to be added back. On that, again, the bonus gets calculated. If you go on doing this, there is no coming back or escaping from the calculation cycle. That is why it is not practical to include bonus under this structure to calculate the revised inclusion part. And I feel that this is where the legislation has not considered the practical part of it, and looks like the application of mind is missing. Let's look at the overtime allowance. The overtime allowance is also an excluded component. The overtime allowance is always paid on extra wages, extra work, and on monthly basis. If at all if it is paid on monthly basis, then the revised inclusion part should also be calculated on monthly basis or whenever there is a need. This gives a administrative difficulties and practical difficulties for the employers and HR professionals. If so, is there any ideal solution? In my opinion, yes. I'm not going to talk in this session. If you would like to know more details about it, you can reach me on my mobile 9880561980 or write to me over my email govind_ns@yahoo.com or mlrauthor@labor-relation.com. My idea is to bring these complexities to the people who need it. That is why don't forget to subscribe to my channel and also write to me in case if you have any feedback. Thank you.